Hi, welcome to our Elder Law Report, and today's topic is inheritance planning for heirs with disabilities. This is something that is near and dear to the heart of someone who has a child or grandchild with special needs, or maybe some other family member. I represent a number of mothers of autistic children, and I've never seen someone more compassionate and whose life is really centered around the care of that child now, and if something happened to them, to ensure that there would be a money stream, income flow, caregivers, that everything would be lined up and in place to care for that child if something happened to them. That is extremely important with any child or grandchild, especially with special needs individuals. And I'm going to go over three main ways to protect the money you want to leave for those special needs individuals and not impede or interfere with, kick offline their SSI benefits and the Medicaid healthcare component that comes with it. So first, it would be setting up a special needs trust, also called a D4A trust, for a child or grandchild or other family member. You setting that up. A special needs trust can be set up by a parent, grandparent, appointed guardian by the court, or with an order from the court. So if you're a parent, grandparent, you can easily set one of those up, sign those into being. That would be called a third-party special needs trust, where you are setting up the trust for a third party, and a third party, you are funding that trust for that special needs individual. You can assign beneficiaries to that trust. So if heaven forbid, the person you're setting up the trust for passes away, then that money is assigned to go to another family member. Money held in a special needs trust is really considered separate from the assets of the special needs person. Therefore, it does not impede a means-tested benefit like SSI with a Medicaid healthcare component. So a special needs trust, amazing tool to set up and set aside money for a special needs individual. Another huge bonus, or one real necessity for a special needs trust, is if you want to fund the trust with another existing asset and make that trust the beneficiary. Therefore, there's life insurance, investment accounts, and you want the trust to receive all or a portion, maybe a percentage of that life insurance policy or those investment accounts. That trust has to be created during your lifetime, during the person who owns the insured's lifetime. So it exists to be a beneficiary. It can't be created after you pass away. So that is a real reason to go ahead and set up a special needs trust for a special needs family member, because you might not want to place a bunch of assets now in it, but set it up to be funded at your passing by insurance or other investment accounts. Number two would be setting up a supplemental needs trust in a will. A supplemental needs trust is really on par or equivalent to a special needs trust you would set up for someone during your lifetime, but this is a testamentary trust. So your last will and testament has that trust built in as part of the will and is set up at your passing when your will goes through the probate process. That way you can designate assets that are flowing through your will, a portion of them or all of them, to flow into that supplemental needs trust, name the trustee, who could be another family member, and have those assets not flow directly to the special needs individual, therefore preventing what would be seen as a gift also be a curse a blessing would also be a curse, because it would, once they receive those assets in hand personally, it would kick offline those SSI and Medicaid healthcare benefits. Therefore, a testamentary trust can divert that and hold that for the use and benefit of that special needs person to supplement whatever they need during their life. The third way to do it is similar to that, but within an existing trust. So let's say we designed a trust for you that had beneficiaries. We may want to put a sub-trust, that's a supplemental needs trust, within that master trust, so that if you passed away, the trustee of the trust, the successor trustee, would be designated and had rules where they had to apportion part of the proceeds from you passing to that supplemental needs sub-trust. Or it could be all of them. How you distribute your assets when you pass is up to you, and up to you to direct an estate planning and elder law attorney like myself, who also does a lot of special needs planning for families, as to how you want your assets to pass when you pass away. Now, when you sit down with me, within an hour or so, we can really cover a lot of ground, get to know each other, and get into your situation and iron out some different variations of plans that might really work for you and your family, and then pick the best one that fits you. Every estate plan is individual. With special needs individuals in your family, we really want to be contemplative and determine how we want to hold those assets so they're healthy, they're cared for, and it doesn't affect other important governmental and healthcare benefits. I am a big fan of putting the supplemental needs trust in wills and trust anyway, because I don't know when a child or grandchild of mine may become disabled, and I want to plan for contingencies or what ifs that may happen in the future. I'm Greg McIntyre. I'm committed to this as a way of life to help people plan to protect their hard-earned money and property and their loved ones, especially their special needs family members. I would offer a free consult. You can exercise that by calling 1-888-999-6600, or you can schedule right on my calendar online at mcelderlaw.com/scheduling. That's mcelderlaw.com/scheduling. Thank you and have a great day.
Please don't wait.